questions to both of you. I'm going to start with Ms. Rikelman. According to your questionnaire, you're not admitted to practice in any federal court within the First Circuit, and you were admitted to the Massachusetts bar only in December. Since law school, how long have you lived in Massachusetts, and how many cases have you been involved in before any federal court in the First Circuit?
Thank you, Senator. I moved back to Massachusetts, where my parents have lived continuously at the beginning of the pandemic, to help take care of them because they're in poor health. It's been very hard for them to leave their home, and I wanted to be back and close to them so that I could be available to them during this difficult time. So since I became an attorney after graduating from Harvard Law School, I've lived in Massachusetts for 2.5 years. As soon as my work allowed me the flexibility of working in a different location, I moved my entire family back home to Brookline, Massachusetts, where I started my life in this country, and we're all living there together, where my kids are attending public school.
Have you, my other part of the question was how many cases you've been involved in there?
I've been involved in a handful of cases, Senator. A criminal case I worked on when I was in law school, and then a number of other cases that have wound their way through the courts in Massachusetts.
Okay. In your 2007 law review article, you argued that laws requiring convicted criminals to submit the blood samples for DNA testing can't be justified under the Fourth Amendment. In several states, including California, Louisiana, Virginia, and Texas, law enforcement is permitted to collect DNA samples when someone assaults a police officer or a teacher, stalks somebody, or commits a sex crime. In your view, why wouldn't these laws be permitted by the Fourth Amendment?
Thank you, Senator. In the law review article that I believe you're referring to, I was only discussing one exception to Fourth Amendment doctrine called the special needs exception. I was not talking about Fourth Amendment law in general, and under the Supreme Court's precedent for many years, the special needs exception only applies in situations where evidence is not gathered for law enforcement purposes. So that was just the point of my article.
Okay, Ms. Khan, when you applied to serve as a Connecticut Supreme Court justice, you were asked whether, and I quote, the interpretation of the Constitution must evolve with history, end of quote. You said that, quote, the original intent of the drafters is very important, end of quote. But you also said that you, quote, believe our state and federal constitution should be interpreted in light of advances and changes in our society and history. So this question, other than amendments to the Constitution, what changes in our society and history should courts consider when interpreting the Constitution?
Thank you for that question. First, I want to say that if I should be so fortunate to be confirmed, I would follow Supreme Court precedent and Second Circuit precedent in interpretation of in any constitutional interpretation case. When I was responding to that question, Senator, what I was referring to is first the text of the Constitution and the intent of the founders is primary and very important. But we also must recognize that the Constitution is an enduring document and that our forefathers could not have envisioned some of the changes, for example, in technology that would affect Fourth Amendment issues, unreasonable searches and seizures, and that's what I was referring to there.
Okay. Ms. Rikelman, in 2018 Huffington Post report, you described crisis pregnancy centers as faux clinics and suggested that their goal is, quote, to trick women who are seeking abortions or contraception services into visiting their facilities, end of quote. In 2017 blog, you accused crisis pregnancy centers of, quote, purposefully misleading women about their mission, end of quote. You obviously have firmly held views on these centers. Will you commit to recusing yourself from cases involving crisis pregnancy centers?
Thank you for the question, Senator. In those articles, I believe I was speaking in my role as an advocate. The only way that I've been involved in litigation relating to pregnancy centers is in defense of consumer protection laws that were enacted based on evidence that some women had felt misled about the types of medical services that were available at the centers. But of course, should I be fortunate enough to be a judge, I will carefully look at the recusal statute and consider all of the circumstances of a case, consult with my chief judge, and do absolutely whatever the Code of Judicial Conduct requires.
Yeah, Ms. Rikelman, a very short question, Mr. Chairman. If confirmed, will you faithfully follow the Dobbs decision?
Absolutely, Senator. I want to assure you that I will faithfully follow Dobbs and all Supreme Court precedent because nothing is more important to me than the rule of law in our country.